expect everyone from the lounge as well to come to the auditorium immediately, please. I repeat and request, please, everyone from the lounge, reassemble in the auditorium, please. Good afternoon, ladies and gentlemen. Welcome you all to the second session of day one of the Delhi Arbitration Weekend 2024. As I said in the morning, the only thing sweeter than union is reunion. So I'm happy that most of us have reunited here, learned panelists as well as the guests. The second topic for the second session today is the past, present, and future of SIAC arbitration. Just to give a brief introduction of the topic, SIAC was established in 1991 as an independent, not-for-profit organization and has a proven track record in providing neutral arbitration services to the global business community. SIAC arbitration awards have been enforced by the courts of India, UK, USA, Australia, China, Hong Kong, amongst other New York Convention signatories. The panelists will shed light on several noteworthy changes and revolutions introduced by SIAC to the arbitration process and discuss provisions of the draft new rules as well. The session will also address SIAC's key partnerships and initiatives in India that have contributed to the development of arbitration in India. I have the pleasure of introducing some eminent luminaries here on the dais. It's my absolute pleasure to first introduce the chair of the session, Honorable Mr. Justice A.K. Sikri, former judge of the Supreme Court of India. Justice Sikri started his practice at Delhi High Court in 1977 and handled all types of cases with specialization in arbitration, commercial, and constitutional matters. Justice Sikri was designated as a senior advocate by the Delhi High Court in 1997 and became a judge of the court in 1999. In 2011, he became the acting Chief Justice and was elevated as the Chief Justice of Punjab Haryana High Court in 2012. A year later, he was appointed as the judge of the Supreme Court. Currently, he is also the judge of the Singapore International Commercial Court. His latest book, Constitutionalism and Rules of Law in a Theatre of Democracy, is an excellent read for all. Amongst many positions, he is currently the chairman of National Court Management Systems Committee, chairperson of the Committee for Formulating an Action Plan for Online Dispute Resolution under Niti Aayog, and the chairman of News Broadcasting Standards Authority. On a personal note, I believe almost everyone sitting in audience here, including myself, have learned and gained under his tutelage and guidance. And I, on behalf of the entire DAW committee, wish him a very happy birthday as well. We welcome you, sir. We also have with us on the panel Ms. Shwetha Bidhuri, Director and Head, South Asia, Singapore International Arbitration Center. Shwetha joined SIAC in November 2018 and is based in the SIAC Mumbai office. She was enrolled as an advocate in 2007 and holds a Master's of Law degree. Prior to joining SIAC, Shwetha worked in the dispute resolution practice of a leading law firm in New Delhi, DMT, for nearly a decade on commercial litigation cases, as well as investment treaty arbitrations involving foreign and Indian investors. Shwetha has worked on many leading cases which have contributed to the development of law affecting global companies. We also have on the dais Mr. Alastair Henderson, Southeast Asia Head of Arbitration Practice, Herbert Freehills LLP. Alastair has more than 20 years' experience handling major disputes across many sectors and industries, with particular experience of oil and gas and power, construction and engineering, and is very familiar with disputes in or concerning the countries of Southeast Asia, including international cases outside the region. Alastair has served numerous times as sole arbitrator, co-arbitrator, and presiding arbitrator, and has handled many cases as counsel under the rules of ICC, LCIA, SIAC, as well as HKIAC. He is a fellow of the Singapore Institute of Arbitrators, a national committee member of the Chartered Institute of Arbitrators, and a former member of the ICC Thailand National Arbitration Commission. We're also joined on the panel by Mr. Vijayendra Pratap Singh, Senior Partner and Head Litigation, AZB. With over 20 years of experience, Vijayendra heads the firm's litigation and dispute resolution practice in Delhi. Vijayendra represents clients in international, commercial, and domestic arbitrations, including corporate and commercial litigation, regulatory practices, and securities law. Vijayendra's expertise span domestic and international arbitration, as well as disputes in various fora in India, ranging from shareholder disputes to corporate action. Last but certainly not the least, we also have on the dais Mr. Ankit Goyal, partner, Allen & Gledhill LLP. Ankit's areas of practice cover international arbitration and cross-border dispute resolution in Asia with a focus on India-related disputes. Prior to joining Allen & Gledhill, Ankit was a lawyer in the Hong Kong office of an international law firm. From 2009 to 2012, Ankit was head of South Asia and counsel at the Singapore International Arbitration Center, where he supervised and administered approximately 150 arbitrations. He has acted as counsel on several cases under rules of major arbitral institutions, including SIAC, ICC, and the LCIA. He has also considerable experience supervising, coordinating, and managing commercial litigations in a wide number of countries in the Asia-Pacific region. With that, I welcome the panelists, and may we have a huge round of applause for the panelists. Without further ado, I hand it over to Justice Sikri to please take it forward.
Thank you very much, and good afternoon to all of you. It's always nice to be back in Delhi High Court, where I started my career as a lawyer, then as a judge, and there are very, very fond memories with this institution. This session, which we are going to discuss about the past, present, and future of SIAC arbitration. One would wonder that why we are discussing about one particular institution, SIAC, and why we are discussing its past, present, and future, that too sitting in Delhi. To tell you in the beginning itself that what's the theme. Of course, we would be discussing about the success story of one of the uh, recent in that sense, because it was established, as we were told, in 1991. So therefore, in comparison with LCIA or ICC, etc., and all other big institutions in the world, arbitral institutions, SIAC is comparatively young institution. Notwithstanding that, the strides which it has made in last now 32, 33 years, it is phenomenal. And therefore, the purpose is, when we discuss about the past and present of SIAC, is to learn. That is what I would say, sitting in Delhi and under the aegis of this conference which is going on, DIAC, which is much more younger, which was established in 2007 or 8. I was the first person there in the committees. At that time, Chief Justice had put me in DIA for the establishment of DIAC. But then, as we know, I mean, as students also, as children also, we learn a lot from the biographies and autobiographies of the great persons. So as an institution in India and how we should grow, I think there's a lot to learn from SIAC and its success story. So therefore, take it in that sense that what we are going to discuss about the past, present, and future, what experience which SIAC has undergone, what advantage we can draw from there. I feel that we have to look into this entire discussion from that prism. So insofar as SIAC is concerned, and that is past and present and future as well, where SIAC is going, and in this context, it has come out with the new rules, draft rules. And when we discuss about that, again, I would say any institution, arbitral institutions particularly, wherever they are, and they have to, the nature of arbitration is changing very fast because of so many reasons, global reasons and other particularly international arbitrations. So therefore, arbitral institutions have also to keep pace with that. New challenges which come, how to meet those challenges, how to give the stakeholders, because arbitration is party autonomy driven process of resolving the disputes, where the parties have full freedom. Interestingly, when we come to rules, etc., I'll say more on that at that stage. In spite of that, when you want to resolve, or the two parties want to resolve their disputes with some arbitral institutions as the supervising body, we adhere to, or we agree to abide by the rules as well. In some sense, whether it is against party autonomy, because if it is an ad hoc arbitration, the two parties can discuss how the arbitration should proceed, and the procedural and other aspects. But then, as I will say it later, that there are distinct advantages of these rules, etc. And as I said earlier, in order to just be in the league, and in order to give succour or a comfort level to the parties who are agitating or who are trying to resolve their disputes to the particular arbitral institution, it has to keep pace with what is happening all around, and have to see that the changes are made accordingly in the rules. And how the new rules, draft rules, which may come into force in next few months, I think, how they are going to change the way the arbitration is conducted, and how they are going to keep in mind the developments which are taking place all around, and particularly in the arbitration world. So that is what we discuss. It is in this sense past, present, and future. And as far as CX past is concerned and its success story, You have already been informed about it in the beginning. I need not repeat that. I can only say that it has, over a period of time in last these 32, 33 years, done or undertaken some cases which are the, most complicated and most renowned cases in the world. And from 1991 to 2022, it has handled more than 5,900 cases. And if we are talking about international arbitration, it is by no means a less figure. And India plays an important role insofar as SIAC arbitration is concerned, because there are many, many cases from India. And so the persons, as well as, I think, let me tell you here, and my very dear friend, Justice Judith Prakash, she is sitting here, that Indians are in love with Singapore for various reasons. And, and they find that, yes, when it comes to international arbitrations and we have to choose some neutral venue, so for various reasons, maybe because of the proximity also of India with geographically and otherwise as well. So SIAC becomes, in that sense, a forum which is much sought after by Indians. I remember when I was judge in the Supreme Court, one retired judge told me that he had come from Singapore in one arbitration. He said that, look, in this arbitration, the three arbitrators were all Indian, parties were Indian, but we were sitting in Singapore, and because it was a SIAC arbitration and the venue was Singapore, so all the parties, all the lawyers, all Indians, but we were in Singapore. So why SIAC in that sense becomes such a sought after institution, and what lessons we can take from there. So that is what I feel is the theme, and we have to go around that. And after giving you this brief introduction, let us come to talk about some past, a little about that. And Shwetha, since you are today, handling the affairs of SIAC in a big manner, so could you share your experiences, SIAC experiences with India-related arbitrations, and highlight some of the key statistics and notable trends that you have seen over the last decade?
Thank you, Justice Sikri. It's absolutely a pleasure to be seated next to him and talk about SIAC. As you know, Justice Sikri sits as an arbitrator in a lot of SIAC arbitrations as well. I'm particularly delighted to be here. We have two court members in the room, VP on the chair, and there's Tejas, who's seated here. And I'm also joined by our registrar, Kevin, who's also in the room. So particularly, I think it's such an important time for us to discuss about SIAC and also about SIAC's importance for India and India's importance for SIAC. Both SIAC and India have a strong relationship. I think SIAC has grown with arbitration in India. So if we look at the trajectory of growth for SIAC and you put in parallel how Indian arbitration has grown over the years, it would just in a way mirror the growing trends. We've looked at the numbers. Of course, I would get to what Justice Sikri wants me to reflect on the statistics of India-related parties and the number of users that we've seen from India. But I think more important is the deeper connect and the value that SIAC has been able to offer to users to India, particularly for the international arbitrations. We've got a strong Indian team of counsel who are working at SIAC. Besides the 4 court members and 2, of course, VP Tejas, Mr. Harish Salve and Darius, the court. We've also got Cyril Stroff on the board of SIAC. We've got 3 counsel in the team of Secretariat who oversee the running of the case management in the counsel team. The deputy registrar is also an Indian. So I think SIAC's story is incomplete without India. So that's how important it is, I think, in the way SIAC has been able to also very, I think, seriously reflect on how it needs to be responsible and how it needs to sort of take care of the cases that it's been handling, coming from Indian parties. Just in terms of the India-related cases, So in the last 10 years particularly, and I think we've got the last publicly released figures as of 2022, 2023 figures are yet to be publicly announced in April this year. But in the period from 2011 to 2022, we've seen over 2,100 Indian parties use SIAC arbitrations and over 1,300 cases involving Indian parties. And I think that number itself speaks of the trust that Indian parties have found with SIAC in administering their cases. And if I could put this, maybe plot it on a graph in terms of where the lower numbers and the higher numbers have been, maybe the lowest number was about 34 cases in 2011 and 2014, and the highest being over 500 cases in 2020, which included the batch of related cases as well. But on an average, we see about 100-odd cases involving Indian parties, and that number, of course, varies some years, but that's about right, about the numbers that we can count on. In terms of the sectors that we've seen, the India-related cases emanate from a range of industry sectors, and these include maybe predominantly from the corporate, commercial, and then followed by construction, trade, banking, maritime, and shipping as well. And I think an interesting trend that Ankit and I were also discussing earlier is to see how many India-related cases are seated in India itself. And that's a trend that has been increasing. I think with India becoming a prominent seat for arbitration, we've seen about 10% of the cases seated in India. Interestingly, there are cases involving 2 Indian parties which were also seated in Singapore even before we had a clarity of whether 2 Indian parties could choose a foreign seat. So that's also a mix of the choice of seat that we see in cases involving Indian parties. From 2011 to 2022, we've seen about 128 cases where both parties are Indian. And also, I think some misconception when I speak to the users is whether 2 Indian parties, with India's seat can take SIAC, and the answer to is yes. And we see many cases where the parties do make that choice as well. Again, in terms of the trend of, what are the procedures that Indian parties have been using at SIAC, and one reason for the popularity or the preference for SIAC has been the innovative procedures that have been introduced in the rules, from the introduction times and the revisions in the rules itself. And some of being the prominently popular ones with Indian parties are emergency arbitration and expedited procedure. We've seen, of course, a lot of development, with the Supreme Court judgment in terms of crystallizing the position of the enforceability of emergency arbitrations which are seated in India. But even before that judgment came about, we had a lot of cases involving Indian parties where EA was used. And in fact, the trend is now that we see more and more Indian applicants using emergency arbitration provisions as well. So about 28% of the total EA applications that we've seen in the last 10 years have come in cases involving Indian parties, and which had about 31% where Indian parties were applicants and 69% where they were respondents. Another interesting provision that is quite commonly used in cases involving Indian parties is expedited procedure. And that's a procedure which allows you to get an award within 6 months from the date of the constitution of the tribunal, and usually with the sole arbitrator. Also a provision which is very popular in cases involving Indian parties. And we've seen about 140 applications for expedited procedure in cases involving Indian parties. So that's just a broad overview of what the numbers look like in cases involving Indian parties and the usage by Indian parties.
Thank you, Shwetha. Actually, I was thinking, this our Indian Arbitration and Conciliation Act was amended a few years ago in 2019, thereafter in 2022 also. But now, again, a committee is set up which has already given its report, and there may be another amendment as well. So what we have been doing because there's much ad hoc arbitration in India, and therefore, to keep pace with what is happening and what is the necessity because of certain kind of arbitrations and what is required, we have to amend the law time and again. And if it is more an institution arbitration, how easy it becomes, because it is easy for institutions to amend the rules and then keep pace with that. In the last amendment, which was in 2019, there was a recommendation for emergency arbitration, but somehow the parliament did not accept, and this provision was not introduced. Thanks to our judiciary, which is very, very robust judiciary, and Justice Nariman, as you pointed out, even when there is no emergency arbitration provision, whether it is an award or not given by the emergency arbitrator, and whether it can be implemented or enforced or not was the question. And there were earlier some judgments from Delhi High Court and Bombay High Court, where they said that, so look, we cannot, they were also in a way pro-arbitration, in the sense that although there is no provision in the Act, and therefore we can't treat it as an order in that sense, but we can pass ourselves an order under Section 9 so that it is implemented. But then Supreme Court went one step further and gave a very bold judgment that, look, this we can, this is recognizable even within the present scheme of the Indian Arbitration Act. And another thing which, again, you highlighted and which has become very, very important, normally what happens is that when the two parties, international arbitrations are when there's one party from one country, other party from other countries. Indian context, say one Indian party and one, say, from German or UK, etc. But in one case, the Supreme Court ruled that even when there are two Indian parties, they can choose a foreign seated arbitration. And it's again a very, very important decision when it comes to party autonomy. Thank you for giving this introduction. I'll turn to Vijayendra, to you now. Since you are, as everybody is informed, member of the court there in SIAC now, so you are, in that sense, conversant with what is happening inside. And with that experience in mind, and you are a person who is a partner in a very leading firm in India, and on the one hand, and on the other hand, looking into the functioning of SIAC nowadays. So what, according to you, the role which SIAC has played in shaping the arbitration landscape in India, how you relate SIAC's position in India? So would you share some of the key partnership and initiatives in India that have contributed to the development of arbitration in India?
Thank you, Justice Sikri, and a happy birthday. Coming on to how I read SIAC. The manner in which SIAC has been involved and how it's allowed itself to function has a slightly different connotation for India. It's called the Singapore India Arbitration Center. And the reason for that is fourfold. The first reason is, while Shwetha has talked about the transactional nature of the relationship with the number of matters that have gone to court and how many of them have involved Indian parties, you see that there is a strong India focus in the disputes. But what people don't realize is the role that SIAC has played from the side to ensure that the development of an international arbitration mindset gets endeared in India. And you see that through three key initiatives that it took. The first is the 7-judge bench in NN Global, which was looking at a judgment on whether or not stamping stops everything and stamps out arbitration effectively from the landscape. The SIAC intervened and filed an amicus brief there. It intervened to tell the Supreme Court what its learnings on severability were, what and how it plays an important aspect of kicking along the arbitration process with there being an answer available within the rules itself, and how there would be a difference in terms of why a party under an institutional system could still get the arbitration kicking off, but an ad hoc system would come to an end. And what's interesting is the Supreme Court accepted those submissions. So it's one of the few submissions that actually find mention in the judgment. Of course, Darius was fabulous as he always is, and his commitment clearly showed. But what was not evident to the world at large was how quickly SIAC decided to do this intervention and how it was able to get in court in a very short and a tight timeline. But that is the most recent version. 10 years ago, I had a similar call from my friend on the right when he was at the SIAC. So this is the present. The past had my good friend reach out and say that the court is looking at the Balco issue. And Balco is looking at the scope of Indian court intervention in international seated arbitrations. We would want to intervene. It was a proactive call saying that we would like to share what the Singapore experience is. And it's not to tell someone that choose our experience, but at least when you are alive to our experience, you'll be wiser and the decision making would be more comprehensive. And I still remember Ankit sending us certain decisions and reports on the discussions on how emergency arbitrator and how swift fortune brought about a change in law there, which did land with the court, which did say that we need to have a judicial, rather than it being judicially sanctioned, where we could go all over the place, let's get it down in a legislative act. And that was the basis for our amendment of 2015. So you do see two places, two constitution bench judgments of the Supreme Court where the SIAC proactively comes in. In addition to this, it doesn't stop there itself. The next thing it does is when the recent TK Vishwanathan committee was looking at international experience sharing, SIAC was one of the few institutions that actually made a presentation. It reached out to the committee, again on a very short timeline, and shared why it felt certain things need to be done. And this is not someone who's just looking at, therefore, a market to get work from the market. This is someone who's actually, therefore, trying to build out a network, a sense of partnership, which makes the relationship more than just transactional. The last is capacity building. And the best signs of that are the recent MOU with my college. Thank you for doing that. And with the National Law School in Bangalore. And in doing that, you've got people coming down to take a course where they will walk students through the finer workings of the rules. So where else will you find people take time off to try and explain why they have drafted something in a particular manner? How does it work? And is there a reason to do it better? Now, this comes from someone who's invested, who's not just involved, but is committed to the cause. And I do believe, Justice Sikri, that therefore SIAC's relationship is one of a partnership rather than just a transactional handing up of matters and we'll take care of it. So you're right, it is the place of default for a lot of us. In fact, when it comes down to choosing an arbitration clause, I can't think of too many people who will turn around and not have SIAC among the 2 or 3 options on the table. The only problem has been that most of us don't realize that a lot of the rulemaking happens through some of the best in the business coming together and doing it. So we could do with shorter clauses, but because of our training being so much in ad hoc, we end up writing out longer clauses. But I think that's what they're trying to streamline with the new rules as well. The clauses are also shorter. I think that'll be something that a lot of us can take back as the new, improved, and comprehensive answer, which SIAC provides towards doing effective, efficient, and economical dispute resolution.
Thank you, VP. I think that this humane phase or phase of partnership of SIAC with India, it's a very interesting facet which you have stated. And as we know and we have discussed that I think SIAC has grown so phenomenally that it is now treated as in first 10 in the world, and maybe in this, including West at number 2 or 3. So this kind of growth which it has achieved, Alastair, I'll like to, if you can shed some light, and according to you, what are the factors which have been instrumental in driving SIAC's growth? both globally and regionally.
Thank you, sir. And thank you, everybody, for allowing me to come here today. It's a great pleasure to be back in New Delhi. So I was reminding my fellow panelists just before this session, I first moved from London to work in Singapore in 1999. Evidently, I was a child prodigy. And at that time, it was by no means clear that the SIAC would achieve the global ascendancy that it's achieved now. And I think we should recognize that the journey SIAC has come on in the last 25 years has been nothing short of extraordinary. The question why it's achieved that, well, there are 100 different reasons and only a limited number of minutes for me to talk about them. So let me pick a few specifics and one general reason. Firstly, we shouldn't overlook the fact that SIAC's success is a reflection of Singapore's own success and its position. Singapore has achieved its world-class status as a commercial hub, partly because of its geographical location, its independence, its neutrality. It is a highly developed center. It is very open. And all of those factors have been as important for the arbitration center as they have been for Singapore itself as a global hub for business. Next, though, SIAC itself, at least since the early 2000s, SIAC has been relentless in innovating, improving, aiming at excellence, always seeking to be at the forefront of international arbitration. And of course, like all of us, it's not perfect all the time, but you can see what the SIAC has achieved from those early years when you compare it against some of the other regional arbitration institutions in Southeast Asia, which have ambition, but not yet the level of achievement that SIAC has managed to obtain. And so SIAC's drive itself to achieve excellence has been very important in its global success. But not just that, there are other external factors. For example, the judiciary. And again, when I first moved to Singapore, it wasn't uncommon for clients to say to me, well, can we trust the Singapore courts? Are they going to be, favorable to Singapore? Is it a home court advantage, etc.? You never hear that now. There is universally a recognition of the excellence of the Singapore courts and their support for arbitration. And we are fortunate to have Justice Prakash here. She has contributed magnificently to arbitration jurisprudence in Singapore, as have many of her colleagues on the bench in Singapore. We have the very good fortune to have a world-class judiciary that absolutely understands arbitration, absolutely supports arbitration, and delivers judgment after judgment after judgment that helps to reinforce Singapore's place in the international arbitration universe. I should also mention the government, because my work permit depends on them. Sidebar, I actually don't have a work permit, I'm a permanent resident, but permanent resident turns out not to mean permanent in Singapore, it is renewable. Since the late 1980s, the Singapore government has been very focused on establishing Singapore as a global hub for arbitration. They have been relentless and universal in bending all parts of government to that objective. And I don't just mean their strong support for the SIAC. I mean, for example, that they have tweaked the immigration laws to support international arbitration. They have tweaked the tax laws to support international arbitration. They have promoted Maxwell Chambers, which at the time when it was first proposed was a very innovative and radical new facility for international arbitration. The law has been amended and keeps being amended to reflect global best practice in international arbitration. And all parts of Singapore government are always on the lookout for ways in which to support Singapore's position as a global hub for arbitration. One other specific, before I come to the general point that I want to make, one other specific, Singapore has benefited from its complete openness in international arbitration. Arbitrators can come to sit on cases in Singapore. Counsel can come from all over the world to argue arbitration in Singapore. It is a very open environment supported by government to facilitate international arbitration. So look, where does that bring me? It is the alignment and the collaboration of all of these different factors in support of arbitration in Singapore and the SIAC in particular. All of these stakeholders that I'm talking about and many more have the same single-minded vision over 30 years to achieve the status that SIAC has achieved so far. The local bar, the international bar, the government, the judiciary, the arbitration centre, the arbitrators, everyone else who plays a part has been constantly working together in alignment to achieve this. And that, I would say, is the single most important feature that has delivered the success.
Thank you. I think that is very important for institutions in India also to learn from this and this kind of experience and how these best practices and global practices, adoption of that can take you so far. You see, coming to Ankit, on a personal note, I remember whenever I see Ankit, as a sitting High Court judge, one petition came to me under Section 9 for interim measure, and I was sitting on the original side. And we had Bhatia International judgment of the Supreme Court at that time, as per which whether the main matter was pending in the SIAC, Singapore International Arbitration, but Section 9 was filed in Delhi High Court. So the question was whether High Court should look into it or SIAC, because SIAC has its own machinery, its own wherewithal, etc., and they can go into it. As per Bhatia International, I should have decided that because everybody knows, of course, Bhatia International got overruled much later. But then I took a bold step at that time, notwithstanding the fact that there was a judgment of the Supreme Court which was binding on me. But then in common law, we have one good thing that how to distinguish judgments also if you don't want to follow a particular precedent. So I for giving my own reasons, distinguished that judgment on the facts of that case, and I said that go back to Singapore. SIAC arbitration, and since that remedy is available there, so you should not, parties have chosen that forum. So that was the, today it's an accepted norm, but in those days in India with Bhatia International, as I said. And after 1 or 2 years maybe, I found Ankit sitting in my court, and my court master, when I rose for the lunch and went back, says that there's this one boy who wants to meet you. He's from SIAC. I said that why he wants to meet me? I mean, I didn't give him the appointment. So for 2-3 days he came continuously. Then ultimately I said, okay, let him come. And then he said, sir, we are thankful to you for giving that judgment. I said, look, you don't have to be thankful. We judges do our job. And I thought that that was, something which had to be done. And so that therefore that judgment was given. But anyway, that was the time when our friendship started. This is how I came to know Ankit. And thereafter we met a number of times. And as and when I went there to Singapore also for some conferences in arbitration, they came to India with Justice Raja at that time, and we had round table. I was acting Chief Justice at that time. So these are some of very, very good memories. And Ankit, you have, as that was a time when SIAC was upcoming, and the progression and the crucial time, you have witnessed that. And we have been discussing, Vijayendra has said much about what role SIAC has played insofar as its partnership or its guidance to India is concerned. What do you feel that what further can be done to enhance its presence and effectiveness in the Indian arbitration landscape?
Thank you, Justice Sikri. When I thank you to the SIAC for giving me the invitation and being on this panel. When I saw the topic, it was a topic that was obviously very close to my heart, past, present, and future. So when we were sitting on discussing what aspect should I cover, I said, I think there'll be enough discussion on the past, I'll probably talk about the future. And I think when we talk about the future of SIAC's role and its contribution of arbitration in the Indian ecosystem, I think there's a lot that can be done and should be done. I found a very interesting statistic in the 2018 Queen Mary survey that said that 80% of respondents noted that arbitral institutions were best placed to influence the future of arbitration. You don't need to be crystal ball gazing. If you look back from 2010 to now, you've got a bunch of innovations that have come in through SIAC. But I think in the future, a lot needs to be done, and I think there needs to be arbitration thought leadership. So my comments, Justice Sikri, is going to be sort of twofold. One is I'm going to talk a little bit about the accessibility to information, and the second thing I'm going to talk about is institutional collaboration. In relation to accessibility to information, it's a debatable, controversial topic, but arbitral institutions can talk about it. I do think, and again, this was in the 2018 Queen Mary survey, vast majority of the people surveyed said that there's insufficient information to make informed choices on appointment of arbitrators, informed choices in relation to commercial jurisprudence on arbitral awards. So I do think that SIAC as an institution moving forward needs to do more as far as access to information is concerned, certainly in relation to arbitrators. I mean, we're living in a world of Google reviews and all sorts of reviews. You don't go out for a meal without checking what sort of a rating a place has. I think in the future, it's necessary, in fact, imperative, for you to know how your arbitrator, well, may not be Google reviews, but how the arbitrator has fared in previous arbitrations, at least in terms of its conduct of the arbitration. May not be in terms of its subject matter substantive knowledge, but at least in terms of its conduct of the arbitration. And I think if you're talking about 5,000 arbitrations from 1991 or 2,100 arbitrations, Shwetha, from 2011 to 2022, that information is amazing for the users. They need to know how their arbitrators are doing. So I suspect that's something that SIAC should probably look into. Similarly, including that is the publishing of redacted awards. I know that there is a push and pull. You know, it's really interesting. I was having this discussion with Kevin, who obviously finds it very odd to be sitting in the audience while we are discussing SIAC. He's the registrar of SIAC. But we were discussing this about the need for redacted awards. And he said, you know, it's very interesting when you ask users, do you want more transparency in international arbitration? Everybody will say yes. He said, okay, fine. Do you then consent for your award to be redacted and published? He says, no. You can ask somebody else. So having said that, I mean, look, if there's going to be a push towards more and more arbitration, I actually think that arbitration will benefit, commercial jurisprudence will benefit by publishing of redacted awards. So there has to be a via media. I understand that there is a mechanism that's being introduced in the new draft rules. We will see how that sort of works out, but I do think there is a need for SIAC to do more in India. Finally, sir, in relation to institutional collaboration. So as you noted, my journey started in 2010. Every arbitration conference that I attended, there would be a topic, and as an arbitral institution rep, you always got invited to speak on ad hoc versus institutional arbitration. I mean, I'm sorry to say, with all the congratulations to the SIAC, the ICC, the LCI, and MCI, and DIAC that they've done, 90% of all arbitrations in India are still ad hoc. Let that number settle down with you. I actually think you all need to collaborate to target the common enemy. There is a whole lot that needs to be done. I actually would say this, that arbitral institutions in India should have a board inside. Every time a PSU signs an ad hoc arbitration, that's a mark of failure for arbitral institutions in India. I do think there is a lot more that arbitral institutions can do, and I think there is need for SIAC to continue to collaborate with arbitral institutions in India to make sure that there is less and less ad hoc arbitration. I don't want to go into the pros and cons of ad hoc versus institutional. I think you've been bored to death for the last decade plus on that. But I do think SIAC can do more on that front. Just my comments.
Thank you, Ankit. And actually, I was just remembering, you see, SIAC and how it has cooperated with the others. When I go to this Maxwell Chambers in Singapore, I find now ICC has its office there. I find LCIA has, I find AAA also has its office. So I hope one day SIAC is also given its, DIAC is also given its office, and that kind of cooperation is there. We see between India and Singapore. Now, changing the gear a bit, and what we had discussed in the beginning, in my introduction about the SIAC rules. So that progression, let us understand, actually these rules, as I said earlier also, they play an important role in the sense that we have to come to the grip of the, and we have to take care of the new situations which have been emerging. COVID has taught us when there could not be in-person or physical arbitrations, and how it has to be online. And but then when there are online arbitration, you have to have proper protocol for that. And how quickly almost all institutions in the world, they came out with they made changes in their rules or came out with their protocols that in order to ensure due process and fair hearings, even online, what is the process which should be followed. So these are, and we have been talking about emergency arbitration, which again was a need of the hour. These kind of situations arose. Expedited procedure and expedited arbitration within 6 months or within 3 months. Some of the cases which can be decided. To tell you, even in our Indian Arbitration and Conciliation Act, there is a provision for expedited arbitration, and rather incentive is given to the arbitrators or arbitral tribunal. If you are able to decide within 6 months, then the fee, which is in our 4th schedule of the Arbitration Act, then fee is enhanced. I don't know, I was just wondering, I have given few awards within 6 months, but whether 6 months period starts from the constitution of the tribunal or it starts after the pleadings are complete. Because if, the pleading itself takes 6 months, you can never give within 6 months. But I have given many awards within 6 months after the completion of the pleadings. But then I never asked for enhanced fee because I did not know whether I qualify for that or not. But then these are, what I'm trying to say is that the arbitral rules have to take care of all these emerging situations. And the SIAC has come out with the draft rules which are going to be going to be brought in force. It talks of streamlined procedure, expedited procedure, consolidation, coordinated proceedings, preliminary determination, and all these aspects. So, Shwetha, would you like to provide an overview of the expedited procedure under SIAC rules and share some of the insights about this what this expedited procedure is?
Thank you, Justice Sikri. So, of course, when we talk about institutional arbitration and the purpose of arbitration in general, the most important underlying purpose is the efficiency in arbitration. And I think expedited procedure, which allows parties to get their award within 6 months from the date of the constitution of the tribunal, has a very, very important role and value to the users. This procedure was introduced in 2010 with the general threshold, the monetary threshold was about 5 million. So there are 3 conditions under which a party can apply to the institution for their case to proceed under expedited procedure. One is the monetary threshold, which is that earlier it was about 5 million, and now under the 2016 rules, it was extended to 6 million Singapore dollars. So if your case is under 6 million Singapore dollars, you could apply. Or if both parties agree, or in the case of an exceptional urgency, under either of these circumstances, an application could be made to the tribunal to proceed the case under expedited procedure and get your award within 6 months. Typically, it is the sole arbitrator who's appointed on a case in an expedited procedure which also goes back to the point of efficiency. The purpose of EP is to be able to allow parties to have significant time and cost savings. So EP has been very popular, not just with Indian parties, but overall in the cases that we've seen at SIAC, about 800 odd applications, from the time it was introduced under the SIAC rules. So just to give a context to, under the three heads, which is the most popular category under which the parties apply. So first being the monetary threshold. Usually these are straightforward, not so complex, lower value disputes that the parties apply for an EP for, and which is why the monetary threshold is the most popular one under the heading of which the party says, okay, this is a low value dispute, we would like to proceed under expedited procedure and get it done within 6 months. The second, sometimes it's within the contract that they have pre-agreed that we would agree to proceed under expedited procedure. They have a clause specifically to specifically provide for an agreement for EP, or it's the post-dispute that the parties say we would like to proceed under expedited. But none of these really give them an inviolable right. It's not that just because you have said we fulfill the criteria, therefore the case would proceed under expedited procedure. So the SIAC has the discretion to determine, because not always a case which is low value would be straightforward. So the amount in dispute does not necessarily correlate to the complexity of a case. So you could have a low value but still a very complex case. So that discretion is still with SIAC to determine whether or not a case is fit for expedited procedure. But I think a very important tool to the parties to be able to have efficiency in their arbitration. And now, the proposal, of course, Alastair is going to talk about what the changes are being proposed to be introduced in the new rules. But the idea is to be able to have more access to this efficiency to the parties. To be allow more cases to proceed under a basis where you don't typically need every case to go in for a full-fledged hearing, cross-examination of witnesses. And also, interestingly, EP is not, like it's still, you're still running through the entire arbitration process, but in a truncated manner. So you still have the processes that you are following, but it just shortens the time period for it. So it allows parties, because you're able to complete it in that, literally, I think about it, safe to say, half the time period that you would otherwise take for your case to be completed, and that means significant impact on the cost as well. So EP has been very, very useful to the parties, and I'm particularly excited with the base becoming wider in terms of the threshold to have more cases to proceed under EP, and to have more, I think, default for documents only procedures, for the case to be decided, rather than impress upon the need that we all need to be heard at length and to have that extensive hearings in a case. And I think that's really an important walk away in terms of how the arbitrations are being conducted as well. I think that also in a way is the next step, that you see more arbitrations which are solid on written advocacy rather than focusing so much on oral advocacy and the hearings, at its own self. So while you keep all that is necessary intact, but to be able to provide for stronger efficiencies within the rule itself. So EP is something which has been very, very useful, and I'm personally excited to see, how the new rule would sort of unfold with parties' greater uptake of the provision itself.
Thank you, Shwetha, for shedding light on this aspect. Actually, one thing which we say, and the common feature, and which is expected of any arbitration, is that it has to be cost effective and it has to be time effective. And in that sense, EP is really a welcome step. And with the proposed changes and these rules, Alastair, now I'm requesting you, although Shwetha has touched upon this, do you think that these changes would increase the number of EP arbitrations, and how useful it would be insofar as saving the time and cost is concerned?
Thank you. So under the new draft rules, there are broadly three types of arbitration. There is traditional SIAC arbitration, full fat. There is expedited, semi-skimmed, and there is the new streamlined procedure that Ankit will talk about, which is skimmed arbitration. And I'm here to talk about the semi-skimmed changes. What is going to change under the draft rules? I'll mention 3 things. 2 control the access to expedited arbitration, and 1 controls the conduct of expedited arbitration. So, firstly, the financial threshold will increase from $6 million Singapore to $10 million Singapore. And that, I think, is a welcome change, just to increase the eligibility pool. As Shwetha has said, it doesn't automatically get you through the gate, but it expands the scope of cases that may be eligible under that particular criteria. Secondly, and in some ways I think actually more significantly, it used to be provided in the rules that you could apply for expedited arbitration in cases of exceptional urgency. And that qualification criteria has been amended in the draft rules to provide for expedited arbitration where the circumstances of the case warrant it, which I think must be a welcome change. Cases of exceptional urgency may be one reason why the circumstances warrant the expedited procedure, but by no means the only circumstance, and this gives the process much greater flexibility to accommodate a broader range of cases which, for whatever reason peculiar to that case, are suitable for the expedited procedure. So I think those 2 changes will significantly widen the gateway. What then if you are in the expedited procedure? Well, draft rule 14.3 provides that the tribunal can adopt any procedure that it considers appropriate, taking account of the expedited nature of the proceedings. And that too, I think, is an important change, not because it introduces something totally new, because in fact the examples that are given in the rules to limit document production, to limit the number or the length of written submissions, to limit witness evidence, those things are happening already. But the point of stating it in the rules is to clarify and confirm that the tribunal can take those decisions. It has the power to be creative in its approach to the procedure of expedited arbitration, and it expressly says that the tribunal should consider the expedited nature of proceedings. And this, I think, goes to the perennial issue of due process paranoia. And anybody who's stumbled across my witterings on LinkedIn will know that I have a thing about due process paranoia recently, and the fact that tribunals should, get a bit stronger about saying, this seems to me the right way forward, and this is what I'm going to do. And I've talked about a case from the Singapore Court of Appeal called China Machine, which I think is very important in that respect. But the point of this change in the rules is to say to tribunals, you've got the power to do this. You can adopt different procedures, taking account of the expedited nature of the proceedings, and you should do so, because you have a duty to progress the case economically, expeditiously, and efficiently. So I think that change in the rules will be empowering and facilitating to the expedited procedure. And together with the broadened gateway, I think we will see this become even more popular than it already is now.
Thank you, Alastair. And in these new rules, we have also, and Alastair has mentioned about the innovative streamlined procedure. And this streamlined procedure, as I understand, is a provision permitting parties to seek preliminary determination of any issues in the arbitration. So, Ankit, would you like to explain what these provisions are and how they would be helpful to the parties?
Sure, sir. I should caveat my response to say that this is all part of the draft version of the 2024 rules. They are still under consultation, so this may not be the last word on how the rule may play out, but there may be iterations of that here or there. But let's talk about what these new additions are. Actually, there are 2 new distinct additions into the rules. One is the streamlined procedure, which I love how Alastair says is a skimmed version. And the second is early determination or preliminary determination of issues. I'll deal with them separately, but very quickly, I think streamlined procedure, in my view, is going to be the most impactful change or innovation that SIAC is going to bring about from the time that it introduced the emergency arbitrator and the EP in 2010. It has the ability to bring in, to fold a much larger number of contractual commercial disputes, which up until now found institutional arbitration to be too cost effective and perhaps inefficient for the sum in dispute involved. So what is the streamlined procedure? A streamlined procedure, if you thought expedited procedure was fast, is faster still, or skimmed further, to use Alastair's term. Streamlined procedure essentially says where either of, or the draft version, essentially says that either of the three things are there, you can apply for a streamlined procedure, either where the parties agree, or the sum in dispute is less than 1 million Singapore dollars, which, depending on what day you look at, is about 6 crore Indian rupees. And the third is, much like the expedited provision, where the circumstances warrant the application of a streamlined procedure. Where any of these three things are there, you can make an application and then the streamlined procedure will kick in. What does the streamlined procedure do? There is a schedule to the draft rules that lays down the streamlined procedure. In essence, what it does is it says that the arbitral tribunal will be appointed within 3 days. The parties have to make, there will be a case management conference that has to be done immediately thereafter. Parties cannot file any witness statements. There cannot be any document production requests. You can file a statement of claim along with the evidence. In most cases, there's not going to be any hearing unless the parties decide otherwise or the tribunal decides otherwise. And those are some of the changes in the streamlined procedure, which is there. And also it says that any reasons that have to be given in summary form. But I think the award has to be given within 3 months. To make it sweeter for the parties to buy into the streamlined procedure, it also says that the administrative fee and the arbitrator fee will be 50% of the schedule of fees, which essentially means that you'll get it in 3 months, you'll get an award in 3 months from the date of constitution of the arbitral tribunal, and you'll only be paying 50%. So that's the streamlined procedure. We don't know how it's going to pass through, but that's the current version. Early or preliminary determination is essentially the power of an arbitrator to bifurcate proceedings. It's been there forever with the arbitral tribunal. It is there expressly under these rules, under the additional powers of the tribunal, but it's now been carved out and there is a preliminary determination which essentially allows for a determination of an issue where if the tribunal feels that it can be decided early, within 45 days, it will decide that. Sometimes these kind of things can be dispositive of the entire arbitration. So that's the preliminary determination.
Can I just add something?
Yeah,
Justice
please.
Sikri? So when you asked Ankit about what the future and what SIAC needs to do more, and he concerned, then of course there's this ad hoc still, which is highly prevalent in India. I think the big answer to this is going to be streamlined procedure. I still get a lot of questions to say, how much should be really the threshold where institutional arbitration is justified? And that question goes away because there is no amount which is too low for an institutional arbitration or too high to say, okay, it's only in such cases that an institutional arbitration would be justified. So I think it really would change the game of arbitration in India, particularly because we see a lot of ad hoc arbitration and sometimes on the pretext that it's a low value and therefore doesn't make sense for an institutional arbitration.
You see, actually that, gives me an idea, and I just thought when you were speaking about it, Ankit, that look, we have the provisions in our Act. It is only because we have expedited, as I said, although the difference is, as you said, in expedited, if a procedure is adopted and the award is given within 6 months, arbitrators are paid more fee. But here in the new rules, they will be, the fee will be slashed by half. But that apart, there is a provision. And likewise, early determination of some of there again is a provision, and applications are filed as well, particularly if the award is to be sought on some of the aspects on admissions in the pleadings, etc., or where it is only purely legal issue which with no evidence which is required, and applications are filed and bifurcation can be there. So on the well-established principle of bifurcation, the only thing is that yes, in spite of there being provision, there is no proper structure, which now we find in these rules. So therefore, how institutional arbitration becomes so important when these rules, and you are able to utilize these, various mechanisms which are provided for expedited disposal of some kind of cases. There's another under these draft rules, another very interesting provision that is of early dismissal procedure, where the cases which are found to be totally, useless, or where it has which are to be thrown at the threshold itself. Though now this procedure is there. So, Vijayendra, would you like to throw some light on this aspect of the procedure in the draft rules?
Thank you, Justice Sikri. Going with the milk analogy, you've heard about skimmed, you've heard about skinny. I'm going to tell you how do you make your milk less fat. And that's exactly what an early dismissal does. It's actually in the nature of ensuring that you streamline your ability to take some things to trial. Sometimes you're able to shut it out immediately, in which event everyone goes home. Sometimes you're able to shut out part of the claim. So effectively, we are playing a strikeout in the course of arbitration. But don't we do strikeouts in court any day? The difference lies in the fact that when you do strikeouts in a private dispute resolution process, you need to meet a particular standard which shows the court that due process is actually followed. And it's in that context, the early dismissal action ensures that you can skim the milk if you find that there is a layer of cream that you don't want. And the way in which you will do that is effectively you will see that there's a high threshold, but you have to meet the threshold of manifestly without jurisdiction or without merit. And that is something that if you can convince a tribunal, you are able to shut out part or all of the claim. And that's important because otherwise you're fighting all of this through to trial. And in doing this, you're effectively taking only those actions which are meritorious into a trial. 3 things to keep in mind when you deal with this. 1, it doesn't work where you have technical evidence or strong factual evidence. 2, it is something which is in the nature of a strikeout, but this is the only place where evidence will play out. So how do you balance the 2 criteria of a right to trial versus the right to shut out? And the best thing that Rule 29 does at present is it says that you will have it. You will have a right to contest a strikeout claim or an early dismissal. The standard is higher, but once that standard is met, you do not have an endless right to trial. So effectively, it does form a part of the 3 inoculations against due process-itis, which most tribunals may at times suffer. So expedited, streamlined, and early dismissal. By working them into the language or the text of the draft, you have effectively given a tool to the tribunal to ensure that the remedy is not worse than the malady. It allows them to streamline it by striking off unmeritorious claims, taking to trial and only taking time on issues that require the time. And last but not the least, doing so in a time-bound manner. So the new rules say 45 days. It's going to be interesting to see how that plays out because I know everyone who's dealt with an early dismissal knows that they have their right to go to court or they have their right to go to tribunals and assert that they should not be shut out. And it's not an easy one to do, but in certain circumstances, it is definitely what you need to do because you can't be taking along the extra kilos that I'm carrying on me when you have the option of losing them. And that's effectively how the early dismissal process works. So these 3 plus emergency arbitrator are effectively the 4 horsemen of the future of ensuring that you will be able to bring arbitration home to economic, efficient, and expedited.
Vijayendra, actually, we know our session started 20 minutes late. So although it's supposed to finish at 1:40, we can go up to 2 o'clock, but we are not allowing you to eat by eating into your lunchtime. So therefore, there was one aspect about interim relief, that is the emergency arbitration. We are skipping that. In any case, much is discussed already about this. So at the end, I would just ask something, one more thing, which in ad hoc arbitration, we always struggle with, is about the consolidation of the proceedings when there are more than one proceedings, or coordinated proceedings when there are, I know there are few cases with me, 2 or 3 arbitrations between the same parties, and how we ourselves deal with those situations either by consolidating if the parties agree, or coordinated proceedings one after other. We in their CMCs we manage that. But good thing here is that again in arbitral process, when it's institutional arbitration, SIAC rules now provide for that. So Ankit, would you like to throw some light on this and take 1 or 2 minutes only, so that we finish in one question each to all of you, and we finish in next 10 minutes?
Very much so. I'll try to be as brief as possible. So consolidation, multi-party contracts, coordinated proceedings are all manifestations of an institution's desire to make sure that arbitral institutions remain relevant in the reality of complex commercial transactions as they are done. Consolidation essentially allows for consolidation of 2 arbitrations in certain circumstances. I don't think I have the time to go through what those circumstances are. Consolidation as a provision has been used multiple times where there is a common legal relationship, ancillary contract, but compatibility of arbitration agreements is actually an important aspect that you need to have for consolidation of proceedings. It is very, very successful, and it makes sure that in high-value, complex corporate disputes and other kind of disputes, it's used, and it allows parties to be able to do things without having to worry about res judicata issues or inconsistent findings by 2 arbitral tribunals. So all of those things really aid parties by having that provision over there. There's also provision of coordinated hearings, which is similar to consolidation, but I suspect we can leave that in the interest of time.
Thank you. And Shwetha, you tell me here the new case management system, which is going to be introduced, and it is going to be launched together with the new rules. So therefore, you will share something more about this system and for the benefit of parties, etc., and how it will work.
I take it my time is also 2 minutes. So I'm going to use half a minute to just tell you that it's important to know what the new rules are, because your parties may already have SIAC clauses, and for which the language provides that it's the rules for the time being enforced which will be applicable. So once the new rules come in, which we are looking hopefully by the end of this year, then the new rules would be applicable to those arbitrations unless they have specifically identified it's the 2016 or the previous version of the rules that would apply. So they would have access to the new provisions, including streamlined procedure, etc., that we're talking, if that comes into force. What is, again, very, very exciting and something that we're looking forward to is the SIAC gateway being introduced into the SIAC arbitrations, which would allow parties to do online filings, be able to make payments, everything online, and will have real-time access to all the documents, everything that would get filed in a case completely. So I think that's going to be quite a game changer in terms of how we've been seeing SIAC arbitrations play out. So something really to look. I'm personally looking forward to how SIAC Gateway will really change the way SIAC arbitrations are being done.
Thank you, Shwetha. And now, Alastair, my question to you, in which I am much more interested, which is that these proposed amendments in the draft rules, how they would affect the process of appointment of arbitrators.
There's one significant change, I think, right from the get-go of an arbitration. Right now, if you file a notice of arbitration, you are expected to name your proposed arbitrator in the notice of arbitration. That requirement is being done away with. So now you will file your notice of arbitration, you will comment on the arbitration clause, the number of arbitrators and so on, but you do not have to include a name. Instead, the rules provide that the parties must jointly propose the name of a sole arbitrator within 21 days of the commencement of the arbitration, or if it's a 3-person tribunal, they must each nominate their chosen arbitrator within 21 days. That, I think, is a good step forward, because to date, a notice of arbitration says, I would like to appoint Justice Sikri as the arbitrator, and almost inevitably the other side go, well, if you want that person, we're not having them. No. So it just becomes a fairly pointless procedure, in my opinion. Whereas this now leaves the playing field level for the parties to talk between themselves about who they want to appoint. Whether they can achieve agreement within 21 days or whatever period is allowed is, I think, a different question. Given that we're time limited, I will just note but not discuss the fact that the draft rules also require that when the SIAC makes appointments, they must now take account of diversity and inclusivity considerations. They must also take account of the nationality of the parties, and where the parties are from different nations, the presiding arbitrator or sole arbitrator must not be from either of those countries. And another time we can talk more about that in detail.
Thank you, Alastair. And last word for you, Vijayendra. And all these significant changes which we have discussed in as less time as possible at our disposal we could. So what do you feel, what are some of the trends you expect to see going forward for CA?
The one thing that I definitely see is the use of the EA. I see increasingly Indian parties looking at India-seated EAs in terms of clauses which have an India seat. The fast-track enforcement available under our law will be one trend that I actually see play out. The second trend that I see play out is the tribunals being more bold with respect to the changes that have been brought about, because the ability to say that due process is not being properly adhered to comes down significantly. And the last piece that I see is what I call Rule 44, which is the disciplining provision. You finally have the ability to call out people for not doing what they're supposed to do in an arbitration, so that you can keep to time, effort, and ensure the objectives of an arbitration are actually met. So I see these three as trends being effectively empowering and working towards serving a solution that the market wants. Not just the users such as lawyers or arbitrators, but the market, which is the client.
I just wanted to add one thing to the trend that he's talking about. I think if the streamlined procedure gets accepted in India, we're looking at a bunch of young lawyers, competent lawyers, and that is really the future of arbitration more generally, getting appointed as arbitrators. So I think that will be a trend worth watching out for as well.
Thank you. I wished Justice Bakru should have been here a little earlier, because some of the aspects which we are discussing and the developments which have been taking place in SIAC, how DIAC can incorporate and one thing I have said on your behalf, that in Maxwell Chambers in Singapore, we say that apart from SIAC, they have the presence of ICC, LCIA, AAA. So we want the presence of DIAC also. Thank you. So with that note, thank you very much. I thank all the panelists for giving this insight, and I think it was quite a good lesson for India as well. Thank you very much.
Before we depart, and at the end of the very invigorating session, I would request Justice Bakru to please felicitate the panelists. So, Sean. Thank you, sir. Thank each and every panelist for gracing us with their presence today. And thank you, everyone.
Great job done, Justice.